Hello friends, welcome to Adisati, your partner in education. So this is the video in continuation with the Constitutional Law Part 1. So let's start with the next concepts. Under Constitution, we have to discuss the next concept of writs. Under Article 22 and under Article 226, there are certain constitutional remedies which are given to all the citizens of India, wherein you can approach Supreme Court of India under Article 32 directly and under Article 226 to the High Courts of your state. Otherwise, you have to follow the protocol as to you have to go to the lowest court possible for the remedy which you seek, and in under Article 32 and 226 you can actually directly approach high courts and the Supreme Court of India, which is given under certain cases. So this the writs are the given remedies under Article 32 and 226. Let's discuss. First is habeas corpus. The first writ, that is habeas corpus, literally means you may have the body. So a writ that commands an individual or a government official to produce the person who has been restrained to be produced at a designated time and place. So in case of wrongful confinements and wrongful restraints, kidnapping, and all the other cases wherein any person has been restrained in a particular place or has been restrained from being at certain place at certain time, in that case you can approach high court or the Supreme Court under Article 32 and 226 into under the writ of habeas corpus. That is, the court would command the adequate authority, the person responsible or the government official or the government authority responsible for the same, to produce the body in front of the court. So this is the writ which is under the individual. This writ is taken by the person other than who has been restrained, because the person who has been already restrained cannot approach the court. Any person on behalf of that person, maybe the spouse or the parents or any other family member who are affected by their restrainment, can approach the court by taking the writ of habeas corpus to the High Court and Supreme Court. So this is the writ taken by the persons on behalf of the person being affected or restrained. Next writ is mandamus. Mandamus literally means we command. It says an order issued by the to a subordinate court or government officer, corporation, commanding to perform certain duties. Whenever there are cases of non-performance of duties by government officials or subordinate courts, it could be courts under district courts or any lower courts. So in that case, this writ is taken to the High Court or the Supreme Court, wherein you request or plea before the court that the court must issue the order. The court has to issue the order to the subordinate court for performance of their duties. So this is the writ which the higher court, by which the higher court issues the order to the subordinate court, government officer, corporation, or any other authority to perform their duties. So this is the or order to direct to perform certain things. Next is certiorari. It says to be informed of or to be made certain in regard to an order of a higher court directing the lower court, tribunal, or public authority to send the record in the given case of review. Whenever there has been cases which you feel that the lower court has passed in a wrong way, that they have not taken the evidence very well, so in that case the aggrieved party actually approaches the higher authorities for review. So in case of certiorari, the order is made by the higher court to the lower court to send the records related to the case which is under review in that particular court to the higher court. So it's an order directing that you send me the file or the record of the case which has been given to me under review against you. That is, High Court gives that order to the lower court. So wherever any discrepancy or any problem arises with the judicial action by the lower courts, the higher courts are approached by the aggrieved parties under the writ of certiorari, and they can actually order the lower courts to send the record to the higher court. So we will discuss prohibition before because it's related to the certiorari. Prohibition is an order of the higher court to the lower court prohibiting it from taking up a case because it falls outside the jurisdiction of the court. In first case, the situation has already arisen, right? So it's a cure kind of a thing. When we say prohibition, we usually use this term that prohibition is better than cure. So prohibition is basically based on that principle only, that you approach the higher court before any loss has occurred. So in that case, higher court would direct the lower court and prohibit that court from taking up the case because it's outside their jurisdiction. So it basically the prohibition against the problem that would arise out of the out of the case which is taken by the lower court out of its jurisdiction. So in that case, prohibition is taken by the higher court by prohibiting the lower court not to take up the case which is beyond its jurisdiction. So certiorari is a cure and prohibition is the prohibition under the term which we use, that prohibition is better than cure. So certiorari is a later stage and prohibition is the primary stage which a person can take to protect his or her rights. Next is quo warranto. Quo warranto is by what warrant? The literal meaning is by what warrant? An order against a person who claims or usurps a public office. It's basically an order wherein the court asks a person by what authority you are doing certain act. In certain cases, public officers or public office or any public authority, when they go beyond their powers, in those cases the writ of quo warranto is taken to the courts and order is given to that person to explain by what powers such act has been done. So this is the writ of quo warranto, right? So I hope this is clear. All these 5 writs, these are very important. So you must keep it by heart. What are the literal meanings of these words? Because these are not English words. So let's go to the next concept of emergency provisions. There can be 3 kinds of emergencies we will discuss. That is, the first we will discuss is national emergency. Second is failure of the constitutional machinery in the state, and last is financial emergency. So let's discuss the national emergency. Article 352 of the Constitution of India provides for the scope of national emergency. Emergency arising from the threat to the security of India. So whenever there is a threat to security of India, emergency can be claimed by the President of India. So when President is satisfied that a grave emergency exists whereby the security of India or any part of the territory is threatened by war, external aggression or armed rebellion, when these 3 cases are suspected by the President of India, so in that case he can actually claim the national emergency. By 44th Amendment, the expression internal disturbance was replaced by armed rebellion. Earlier, in place of armed rebellion, there was a term used was internal disturbance, which was replaced by 44th Amendment to the Constitution of India. So when these 3 cases are satisfied, or any of the 3 cases has been satisfied, the President can claim national emergency. President's power are subject to the recommendation of cabinet. The president himself cannot claim emergency. It's the cabinet to president which gives the recommendation to the president that the situations out of these 3, any of the situation out of these 3 has been suspected and there is a threat to security of India. So you exercise your powers under Article 352 and claim the national emergency. So he himself cannot proclaim emergency. The proclamation may or may not extend to the whole of India. So the emergency can be applied to certain regions in India. So there is no mandatory rule that it has to be applied to the whole part of India. So far, national emergency has been declared thrice. First in 1962 during Indo-China War. Second is 1971 during Indo-Pak War. Third is imposed in 1975 on the grounds of internal disturbance. So what is the basic nature of emergency? That there is a suspension of fundamental rights and other consequences. Most of the fundamental rights are suspended, but like we discussed in the previous video, Article 20 and 21. Article 20 relates to the protection against the conviction in cases of offense, and Article 21 is right to life. These are not these are some of those rights which are not suspended during emergencies. However, other rights like freedoms and etc. could be suspended in cases of the emergency situations. Next is Article 356, the second type of emergency, that is failure of constitutional machinery in states, or it is termed as the presidential rule or president's rule. Whenever the constitutional machinery of the state fails, the President of India can proclaim his rule within the state. So it says president satisfied either after the report of governor or otherwise. So in this case, he can actually take up the case on his own or by the report of the governor of the state, that the government of the state cannot be carried on in accordance with the constitution, that the situation of such kind has arisen that the government of the state cannot be carried on in accordance with the provisions of the Constitution of India due to various circumstances. For example, no party has a majority in assembly, or widespread breakdown of law and order. So the examples given are that in elections there is no party which has enjoyed the majority, so no government can be formed, or there is a breakdown of law and order, like you know armed rebellion comes into play, or any kind of disturbance which comes into play in the state, and there's a breakdown of law and order completely, and it cannot be controlled. So in those cases, president can claim the emergency under Article 356. President assumes to himself the functions of the state. He is the one who performs the functions, and powers of governor also vest into him. The governors and powers are also given to the president, and all the powers of legislatures, state legislatures, are given to the Parliament of India, right? So the powers of state and the governor are given to the president, and all the powers of state legislatures are given to the Parliament of India. Proclamation of emergency is declared for the period of 6 months. First is it can be given for 6 months. It can be extended for another 6 months, however, with the approval of Parliament. So next 6 months is with the approval of Parliament. But the whole proclamation of emergency under this article cannot be more than 3 years. So it can be extended up to 3 years. First 6 months is without approval of Parliament. Next 6 months and after that till the period of 3 years can be with the approval of Parliament. So this is Article 356. Next is Article 360, that is financial emergency. President satisfied that the situation has arisen whereby financial stability or credit of India or any part thereof is threatened, he may proclaim financial emergency. So it relates to monetary and credit basis. The financial stability is threatened in India or any part thereof. In that case, financial emergency can be proclaimed by the president. Center can give directions to the state to observe certain canons of financial propriety. For example, reduction in salaries and allowances. So, state actually directs and observes and gives the methods by which the state can come out of such financial emergency. For example, by reducing the salaries and allowances of the employees. Reduction in salaries and allowances of persons serving union, including Supreme Court and High Court judges. So basically the reduction in salaries and allowances is actually with relation to the government employees or the employees under the Supreme Court and High Court. So it also includes judges, as we say. Center may require that all money bills and finance bills be reserved for President's consideration after being passed by state legislature. So any bill that is relation to money bill or finance bill will be reserved, and until and unless the President has given the consent, it would not be passed. The ordinary procedure of state legislature is changed. So in this case, President also comes into play. Not imposed even once till now in the country. The financial emergency has not been imposed till now. So you see the relation between the salaries and allowances of the government employees. So the MPs and MLAs themselves do not want it to be claimed because it would have it might have impact on their salaries. So you can say that this can be a relation between the financial emergency. Although that's a hypothetical thing which I actually said that, like that only. Let's take the next concept, that is amendment. Article 368. Power of the Parliament to amend the Constitution and the procedures. Article 368 clause 1 says, Parliament can amend any provision, amendment by way of addition, variation, or repeal in any of the provisions in accordance with the procedure given. So the Parliament has the power to change any provision by making an addition to it, by changing it, that is variation, or repealing it, actually deleting it altogether. So the Parliament has the power to do so. Article 38 clause 2 says, procedure, introduction of bill in either of the house. This is related to power, and this is relation to the procedure. Introduction of bill in either house of the Parliament. The bill has to be introduced in one of the houses of the Parliament. Upon bill being passed by two-thirds of the majority, those present and voting, sent to the it has to be passed by the two-thirds of the majority of the members of Parliament, and then it is sent to the President for his assent. In some cases, amendment needs to be ratified by more than half of the legislature. So actually it's a two-third majority, but in certain cases it can be more than half of the state legislatures. In certain cases the state legislatures are also playing an important role in passing such bills. Article 368 clause 3 says, nothing in Article 13 shall apply to any amendment made in this article. We had this clause was given in Article 13 also. So herein also it says that any provisions of Article 13 would not be applied to the Article 368. So here also the basic structure comes into play, that the amending power is not absolute. The basic structure of the Constitution of India cannot be changed. The miscellaneous concepts related to judiciary are, first is court of record. Article 129 says, a court of record is a court whose acts and procedures are enrolled for perpetual memory and testimony. These records are used with the high authority and their truth cannot be questioned. In Indian Constitution, Article 129 makes Supreme Court the court of record. Article 215 empowers high courts of the states to be the courts of record. So it says all the acts and proceedings and cases are recorded for by certain authorities. For example, All India recorders and Supreme Court cases. All these records are basically under Article 129, wherein the Supreme Court has been declared to be the court of record, and all the cases of Supreme Court are recorded in them. So Article 215 on the other hand provides the powers to high courts to be the court of record. So their procedures and acts would also be recorded under Article 215. Next concept is doctrine of stare decisis. It's a very important concept. It's a legal principle by which judges are obliged to respect the precedents established by previous decisions. This policy dictates that court must abide and adhere to the decided cases. It's basically whenever a case has been given by the higher authority. For example, Supreme Court states certain principle that right to life includes right to privacy. Right. So example is right to life includes right to privacy, right? So it has been established by Supreme Court, right? So all the lower courts as well as the lesser benches, for example, three judge bench has given this judgment under the Supreme Court. So all the benches less than three judges would have to oblige the decision given by the Supreme Court, and also the lower courts other than the Supreme Court will have to go by the decision of the court. That right to life includes right to privacy. So it is under the principle of doctrine of stare decisis. That is, judges are obliged to respect the precedents set by previous decisions. Next is the concept of elections. What are the fundamental principles which are followed under the elections? These you must be knowing as a citizen of India. There's a one general electoral roll in the constitutionally. Electoral roll is there for the whole constitution. The elections are held on the basis of adult suffrage, that is, the right to vote is given to all the major citizens. The person has to be Indian citizens, not less than 18 years. Anybody who's above the age of 18 years is treated to be adult and has right to vote. And the person has not to be disqualified, that is, he must not be of unsound mind and he must not be criminal, because those people are generally restricted from voting. There are reservations for scheduled caste, scheduled tribe, and Anglo Indian. So these are the basic fundamental principles which are followed for the elections. Next is the important body which governs the elections in India is Election Commission of India. It's basically a body who's constitutionally empowered to conduct free and fair elections to the national and state legislatures. And the Election Commission of India in India is a three-member body wherein there is a chief election commissioner and two election commissioners. It's a multi-member body and all the decisions are taken by way of majority. Chief election commission is not primus inter pares. That means he's not senior to the election commissioners. They are treated equal. No, he's not the first amongst equals. So all the decisions which are taken by election commission are based on the majority. Recently, Nasim Zaidi is the person who is the chief election commissioner, and other election commissioner are Achal Kumar Jyoti and Om Prakash Rawat. So these are the three persons who form the Election Commission of India. So this is the basic concept of election which is followed in India, and Election Commission has been given the Constitution of Election Commission has been given under the Article 324 of Constitution of India. So these are the concepts we had to discuss under this PPT. Thank you.